All right. Well, good morning, everyone. This is JJ Richa with Pismo Ventures and with the National Venture Plan Competition. We, as you may know, the competition for round two has started. And yesterday we had the B2B category where the 15 companies competed. And we chose the top three with the highest scores to move to round three. Good to have you here. I have so on Thursday we have the B2C category. Next week on Tuesday we will have the life sciences category, and then the final category would be Thursday next week, which is a wild card category. So hope everyone is able to connect and see and watch and learn and get some feedback. That's really great. So the round three will start the last week of October. And then it would be really the final round where there are 10 companies that will be competing for the top three spots. So hope everyone can really join us. We still have webinars going on. So we have one today with Morgan. We have one on Friday as well, and then we have I think 2 next week. So I hope you're finding all these webinars very useful, because I really think they are. I'm learning every time. I learn at least a thing or two, although I think I know most of the stuff, but I find out that I'm not. I don't know much. So I'm gonna leave it up to Morgan to take it from here, and please introduce yourself, Morgan, and tell us what you're going to talk about.
Sure thing, JJ, and don't worry, lawyers learn new things every day too. There's new laws coming out every day, or you get pulled in, or you learn a new area of law that coincides with whatever you're working on. So you find out how much you don't know very quickly. Greetings to everyone. My name is Morgan Jones. I'm a senior associate McCarter English at a law firm based in the Mid-Atlantic, mainly from DC to Boston. I think we have about 10 offices now. Roughly 350, 400 attorneys. I've been practicing law for about 10 years. I started in-house and then went to private practice, which is the opposite of what most people do. Usually they put in a few years at the firm and grind it out and then go in-house, but I did it the other way around. I started my own path. I started as a patent IP attorney, and I have since then emigrated or migrated over to data privacy. But I still handle IP law from time to time. I do a lot of work with startups. I'm in our emerging growth venture capital group here at McCarter English. So I'm very well versed in the plights and the common issues that come up with startups. And I know what you're facing, and I know what you're going through and about to go through. So my goal today is to just give you a taste of what is going on in privacy law, which might not mean much to you now, but I assure you, your investors or your future investors, your would-be investors, do care about it. So you will have to care about it at some point, and I'm going to try to give you a good roadmap there and give you the general principles that you need to be aware of. And then we're going to talk about intellectual property, and we'll cover the few types of intellectual property there are, and some basic strategies there as well, and plans to make for intellectual property as well. So with that, I think we can dive on in, unless JJ had something else to add.
No, we're good to go. The floor is yours.
All right, and please, by all means, if you have a question, fire at me as we go. I think it makes for a better response.
Yeah, and please put the questions in the Q&A section, not in the chat. It makes it easier for us to moderate.
Great. JJ, just if I'm ignoring a question for too long, call my attention to it, please.
I will. I'm here. Yep, I will do that.
All right. So can everyone see the screen? Are we good? I hope so. Like I said, we're going to talk about privacy and intellectual property for companies pre-funding, or maybe you've had a little bit of funding, but you're looking for more. Because typically the further along you get in price rounds, the more difficult, the more strenuous the diligence takes, or the more diligent and more strenuous it is. So someone who might have overlooked things in like a pre-seed round might not overlook it in a B or C round. So, okay, that didn't work. Just a few formalities. Everything discussed today are my own thoughts and opinions, not those of McCarter English, and certainly not those of Pismo Ventures. Nothing here forms an attorney-client privilege, and nothing here is legal advice either. So our general overview today is we're going to cover privacy first. Get that out of the way. I know a lot of people yawn when they hear privacy, but it is a growing topic. It's really exploded in the last few years, and the investors care about it because it will impact the valuation your company receives if you are ignoring the privacy laws. So because they care about it, you're going to have to care about it. The two laws we're going to talk about today are the GDPR, which is in Europe, but it will stretch across the Atlantic and find you over here, I assure you. And then there's the CCPA, which is the California privacy law. For intellectual property, we'll cover patents and trademarks and copyrights, trade secrets, and we'll do a little discussion about licensing as well. And then we'll just do some question and answers at the end. But again, if you have any questions as we go, please don't hesitate. So the European Union has a number of different laws and regulations and directives that touch on data privacy a little bit. But generally speaking, the big bad in the room is the newest one, and that's the General Data Protection Regulation. This came into effect Memorial Day, roughly 2018, and has been just causing a lot of headaches for people outside of Europe since then. Not to say it's an unfair law. There's a lot of aspects about it that are very fair and industry neutral and tech neutral, but it does impose quite a few burdens, and it's hard for some people to see why the law on the other side of the ocean needs to impact them. But we'll get into that. So, personal data, according to the GDPR, oh, we have our first question. Reputable texture on patent. Okay, we'll save this IP question for when we get to the IP section. I think that is the best way to deal with that. So let me just put a pin in that for now. Mohan, if you could ask that again when we come up to the IP section. So personal data is virtually anything that identifies or could be used to identify an individual person. For purposes of the GDPR, they focus on people who are located in the European Union, the European Economic Area, which I believe includes the Nordic countries above the Union, and Switzerland for some reason. Switzerland is neither in the EU or the EEA, but it still is protected under the auspices of the GDPR. The scope of the GDPR, it covers automated processing, which means if you have a script or some other code that will review and analyze data for you, like an AI, manual processing that uses some sort of filing system, but it does not include data you have in like your address book for your own personal reasons. Territorially speaking, it covers companies who are based in the EU and who are doing business with them. If you are also marketing or targeting people in the EU, or if you are monitoring the behavior of people in the EU. So, here. Okay. There are a set of principles under the GDPR that you'll find in a lot of different data privacy laws in some way, shape, or form. So it's really good to have a somewhat of an understanding of what's going on here. Transparency means that you're going to do what you say and say what you do. Usually this happens through a privacy policy that you will post online for your business. If you don't have one already, I do recommend you get one because it goes a long way to complying with the transparency principle. Basically letting people know what you're doing in a clear and not overly jargoned way so they can understand it. Purpose limitation means that when you collect someone's personal information to do a specific task, you won't go and do X, Y, or Z on top of that specific task that you collected it for. There are certain exceptions in the GDPR that allow for like a natural progression. So if you submit an email address and order something online, a natural additional purpose might be they send you administrative emails to say, oh, just letting you know we're shipping your package tomorrow. And then, your package is on its way if something's being physically delivered to you, even if you didn't specifically consent to that. Data minimization is a principle that basically says you're only going to collect the data that you need to accomplish the purpose. Accuracy means you will do your best to make sure that the data is accurate and complete. That can be putting burdens on people who submit it to you, but also making sure that you don't do anything that will lead to it becoming inaccurate. Storage limitation, you won't keep it longer than you need it to carry out the purpose, or if there's a legal obligation you have under a European law, you're allowed to keep it longer, but other than that, you have to really keep it for as little time as possible to meet all your obligations and deliver the goods or services. Integrity kind of overlaps with accuracy. You're going to minimize what you're going to do with it and keep yourselves honest, and it overlaps with accuracy, transparency. Accountability means that you will be held accountable. They have to know, the users, the data subjects, as we call them, have to know who to go to if they have a problem or if there is a complaint. So that is the accountability principle. The GDPR requires what we call the lawful basis. You can have more than one. Usually people go for consent, but I would caution against that because consent can be revoked. So certainly get it if you can, but don't rely on that as your only basis to process personal data. The performance of a contract is very common. Basically, we're collecting your data because you're asking us to do something, and we need that data to do it. So that is a very common basis that people use. Performance of a legal obligation, we touched on this the last slide. That is you have some sort of regulation or law in the EU that is obligating you to do something. Do you have the GDPR compliant template for privacy policies that you can share? There is standard language that you have to include in privacy policies for the GDPR. It's hard to prepare a template of any privacy policy because each company is fairly different. If you would like to follow up with me offline, I'm happy to tell you what needs to be in there, but I would have to leave it to you to put that together, unless you want to talk about that in a separate, offline. We'll talk about that offline. But yes, there's certain things that have to be in there, like what the rights are that people have and who to contact if there is an issue. So, but generally speaking, I don't advise on using any template privacy policies or using privacy policies from your competitors. There's always nooks and crannies that are different, and if something turns out to be false in your privacy policy and there's a complaint, it makes things much more complicated because someone might say, well, you said you'd only process for X and Y because that's what you got from your competitor, but your privacy practices were a little different. You processed for one or two other things too, but you didn't disclose that. So it's really not a good idea to have templates, generally speaking, but we can talk about all the things that need to be in there. Vital interests. This literally means that you are processing someone's data to save their life or the life of someone else. So emergency room doctor goes into your wallet, takes out your ID, says, this is so-and-so, let me look them up in the system based on their license and their health insurance, see if they have an allergy to something so we don't give them penicillin, what have you. Performance of a public task. This is kind of only applicable to public entities. So it's really not going to come up very often. Legitimate interests is a tough point to sell, especially if it's challenged, basically says the company has a legitimate interest in processing the personal data for this reason. You have to justify it by going through a 3-point assessment that some of the data privacy authorities, like the ICO, which is the British agency, the Information Commissioner's Office, have put out. It's a balancing test that we don't really need to get into here, but not everyone uses legitimate interest because you do have to defend it and it can be challenged. It's a lot easier to just rely on performance of a contract, consent, and legal obligation. So the data subject rights. The GDPR gives the following rights to the data subject, which are the individuals in Europe, not necessarily European citizens. I could have European citizenship tomorrow. Doesn't mean anything because I'm not based in Europe. They're focusing on the individuals who are in Europe. So meaning I could fly to Spain or Italy tomorrow, rent a car, and whoever I rent the car from would have to protect my information the same as anyone who lives in Europe. So as data subjects, you have the right to access your information, to rectify or correct, to be forgotten, which means erased or deleted, to restrict processing, which is very seldomly invoked, but this is usually what's asserted when you're relying on a legitimate interest basis for processing. Data portability is interesting. It's a very unique right that doesn't exist in too many other laws. Basically says that you have to make in a commonly used digital format that data subjects' personal data available to basically transfer to another provider of whatever service you offer, free of charge. They have the right to object to processing. Again, this kind of reads on the, excuse me for a second, the right to the processing for legitimate interest, right to be free from automated decision-making. This is a unique right as well. Basically, the European Commission found that many people were being subject to rights by certain criteria that they entered and tried to, say, obtain insurance or approval for a loan, and the computer system that the bank or the insurance company had automatically put them into a certain category and rejected them or some way affected their rights. So you have the right to be free from automated decision-making without the ability to follow up with a human and challenge that decision. You have the right to revoke your consent at any time for any reason. Again, this is why I suggest you do not rely solely on consent. And you have the right to lodge a complaint with a data protection authority. Now, that can be any number of data protection authorities. It could be where you live, it could be where you work, it could be where the offending entity is. So you really have your options, and you should be. This is a cause for concern because certain countries, their data protection authorities are more happy to enforce the law than others. I don't remember the number of complaints there are right now for the GDPR, but I know that last time I checked a month or so ago, there were several hundred, maybe 800, 900, and roughly half of those came from Spain. So chances of getting a complaint or at least a action filed against you in Spain are a little bit higher. So it's something to think about if you ever decide to open a subsidiary overseas, or where, if you have a large population in and around Spain or one of the other hubs that tend to file a lot of complaints. So access, you get to know the purpose and duration of processing, what categories of personal data are flying around that they have from you, the entities in third countries where you may have sent their data, what their rights are. We already covered that. The use of automated decision-making, if any. And if you collect any information about this data subject from a third party, not from them, the identity of that third party and the information you got from them. And you must give them a copy of their data free of charge. You don't have to do this often, or if it's overly burdensome, free of charge. If there's a lot of costs associated with your process to put this together for them, after the first time you can't charge them. Rectification and deletion. Data subject shall enjoy the right to have the controller. We should back up. So there's two parties in the GDPR. There's data controllers and there's data processors. Data controllers determine the purpose and means for processing. Processors work for the data controllers, process data on their behalf, and are akin to vendors. They carry out some sort of function that the data controller either can't do or can't do efficiently or doesn't want to do. The data controller tells them what to do, but not necessarily how to do it, and they don't do it, and then they should return the data. We'll get into this more later, but sorry, computer. You have the right to have the controller without any delay, correct any of your inaccurate data. Rectification, not deletion. And you have the right to complete any incomplete data. Sorry, here's the ratio, right to be forgotten. So there are certain exceptions. This is not a universal right. It's not absolute. It doesn't apply in every single instance. For instance, if the data is no longer necessary, if consent is already withdrawn, there's no legal basis, or if there's an objection to processing and no legitimate interests. There's a few other exceptions. If you don't have to erase data if you need it to comply with a legal obligation, if there's a public health interest, or if you are using that data as part of some legal matter you're involved in, whether you're the plaintiff or defendant. If you need it to exercise or defend your rights, that might even be against the person who is trying to exercise that right. You're allowed to keep the data. They can't force you to delete it, especially if it helps make the case against them. Portability, like I said, you have to provide them a copy, digital format, very machine readable is the language that the law uses. So basically, if it's a lot of data, maybe an Excel file or something that's very common. Don't use some obscure proprietary format. This only applies if consent or performance of a contract is the legal basis, or if processing is by automated means. Right to be free from decisions based solely on automated processing, which means if a person is involved and does quality control, it might not apply, or they might not be able to, the data subject might not be able to exercise the right that we're talking about. The exceptions are if you are performing a contract, if automated decision processing, automated process is allowed by EU law, or if it's based on very explicit consent with the human intervention. So there's rules and exceptions to pretty much everything these days. All right, so controllers. As we said, they are the brains of the operation. They're collecting the data. They know what they're going to do with it. They determine what it's going to be used for. But what's processing? Processing is pretty much anything under the sun that you can think of that you can do with data. Even storage, even very passive storage in your cloud provider is processing technically. There are also, in many situations, the controllers can also be processors. It's a very strange dichotomy, but chances are if you're a controller, you're also acting as a processor of your own to some extent. Again, processor is basically the extra hands of the controller used to do something to the data for the controller as they need to deliver the goods or services to the data subject. So not the greatest example, but again, you're ordering goods from Amazon. Amazon gives your goods to UPS to deliver. They, in essence, are a processor, though there's certain guidance out there that suggests that the mail system or package delivery systems are not processors. But just so to make it a little bit easier to understand. That's what I mean when we talk about processes. So the controllers are responsible primarily to the data subjects for everything, though you can make direct claims against a processor as a data subject as well. So they're overall responsible for GDPR compliance and to make sure that you have appropriate technical and organizational security measures in place. What is appropriate? We don't know. It's purposefully vague, and rightfully so. And I always say that they did this because they recognize not everyone has the war chest that Google and Facebook and Amazon do to invest in their technical measures like encryption, multi-factor authentication, different password policies and procedures. Not everyone can do that. Not everyone has billions of dollars. Some people are lucky to have thousands of dollars, especially when they're first starting up. So the European Commission recognized this and said it depends on what is the state of the art, what your financial capabilities are, what sort of processing you're doing, what sort of data you have. It's a kind of what we call a totality of the circumstances analysis that you have to run. If you're flat broke, obviously you don't have much that you can do, but there's certain things you should always try, like encryption. There's lots of services out there that will help you do this, relatively inexpensive and relatively effective. Some more controller obligations are they have to appoint a data protection officer and an EU representative. So if you're not based in Europe, you need an EU representative, basically so that they can serve a complaint upon you if a complaint is lodged. They should not be the same person. They should be acting independently of each other. You can outsource this to different third-party organizations. They do this all the time. If you don't need to or want to hire someone right now, or two people rather, you need to make sure that your privacy notice, most of us in America say privacy policy, but the rest of the world says that the thing on your website is actually a privacy notice to data subjects to make them aware of what it is you're doing. You need to have data processing agreements in place with your processors. This is absolutely non-negotiable, and the user, the data subjects have rights to request to see those. You have to implement the technical organizational measures, basically protects your data, demonstrates compliance for the data subjects, and you demonstrate compliance to the data privacy authorities. You have to give a notice of breach if you do suffer a breach for some reason, hopefully not. And initially, the burden is on the controller to respond to any data subject requests. Sometimes this gets a little confusing in that the data subjects will go straight to a processor if they're aware of them and submit it, but usually the agreement you have with the processor says that the processor will make the controller aware and let them answer the request. But the controller can delegate that back to the processor if they want. It's totally up to you, but you still remain liable and responsible for that response. Here's a big one, and I will say we'll do a little recap at the end, but this absolutely positively takes the most time if you're trying to build a compliance program, because not everyone cares about the same thing you care about, your vendors most of all. I'll tell you, roughly how far out I think you need to start worrying about this, but it's easier to do at the very beginning before you onboard a vendor when the money is still dangling in front of them. They'll agree to a lot more. So it's easiest to do it at the beginning, but I'll give you a rough time frame later on down the deck of when you should start based on average startup size. So the DPAs have to cover these topics. Basically, one, the processor will only process data on these explicit instructions from the controller, that they will keep everything they get from the controller confidential, that they too will use appropriate technical and organizational measures to protect the data. You have to address sub-processors, which, subcontractors essentially. You can use general authority or give give each processor the general authority to hire them or the specific authority. Typically, to streamline things and make everything just logistically go easier, general authority is preferred, and you have the right to object within a certain number of days after they make you aware of the new sub-processor. Specific authority, you're waiting, they send you a name of a new processor or sub-processor. You have to review it, you consider it, and it just slows everything down. But it's the same issue as, objecting to it after the fact. Processors have to assist the controllers with a number of different tasks, general compliance, data protection impact assessments. They have certain breach obligations. Basically, they have to notify the controller and take certain steps to mitigate any breaches. They have to delete and return data upon request or at the end of the processing. Again, like we were saying, the data subject request, they have to make the controller aware and give the controller the option to respond themselves or let the processor do it. And we have to worry about onward transfer. This is a big one in the last year or so, maybe a little bit longer, because of a case that came out in Europe, basically invalidating one of the big transfer mechanisms that we use to move data from Europe to the US. So that got a little bit more complicated, and it leads to a much longer data processing agreement these days, because you're basically de facto left with the other method, which is like a 15 to 20 page document you have to put at the back of your data processing agreement or addendum. That's called the standard contractual clauses. And if someone tries to get you to use Privacy Shield or say, I'm Privacy Shield certified, we don't need that. Privacy Shield is what was invalidated by the court case. It's no longer valid. They cannot use it. They must use standard contractual clauses or have one of the other few transfer mechanisms in place, which are not easy to do. Like we were talking about. So in order to transfer data to new countries from where you are, one, processor need consent from the controllers. You should not let them do that at all until you've reviewed and considered what's going on, because the GDPR has this concept of adequacy. So the European Commission will review the privacy laws and practices of different countries, one at a time, roughly, and determine if they are adequate or essentially equivalent to what is going on in Europe. 2 years, no, three plus years into the GDPR, and I think there's maybe 15 countries that have adequacy and 1 or 2 pending. So they're very strict about this, very, very strict. The UK just got it, and I think one of the Central America countries is working on it, but very few countries get this. The US does not have it, hence we are using now one of the transfer mechanisms we're talking about here. We're considered a third country, so we need an appropriate safeguard, meaning standard contractual clauses we talked about, or you can have binding corporate rules or a code of conduct, which have to be approved by the European Commission or one of the data privacy authorities in order to transfer data back and forth. And that applies to both parties. Otherwise, you pretty much have to use the standard contractual clauses. There's another concept in one of the other articles of the GDPR called derogations. This allows, just for very limited use, one-off transfers of data. It's not something you want to use or you can use if you are transferring data frequently in a similar manner, because you have to do an analysis each and every time. So you're better off going standard contractual clauses, even though it turns your 10-page agreement into a 30-page agreement. You just have to do it. The good news is you don't get to negotiate the standard contractual clauses. You put them in there, you fill in a few blanks, you sign it, and you abide by it. When you edit it or try to edit it substantively, it opens it up to invalidation, and that could avalanche into some very problematic issues for you down the road. So why does everyone's investors care about this? Because the penalties are absolutely huge. The good news is some of them are discretionary, left to each country to decide. So the big attention getter is that for certain violations, the fine is up to 20 million euro or 4% of annual turnover, whichever is more. So depending on the company, 20 million euros is a lot of euros, and that could be a lot for a small company. But if you're talking about Googles and Facebooks of the world, and there was just like an 800 million euro fine, and I forget who it was for. 4% can obviously be more than 20 million sometimes. So usually this fine applies when there's violations of the principles of the GDPR that we talked about, or consent, violations or neglect of data subject rights, transfers of data to a third country, which, like I said, has gotten a little more complicated. And unfortunately, we don't have a perfect system in place right now. So we're trying to do the best we can. I think there'll be a little leniency from data privacy authorities in this sense for the time being, because again, we really don't know the best way to do anything. There's no clear-cut method to making sure everything is buttoned up in this sense. Or if the last item for the 20 million big jackpot here is non-compliance with an order of a data protection authority. The lower tier fine, half basically, but still 10 million euros is a lot of euros. If you have an issue with child consent, so the GDPR is a little different for anyone under 16, or if you violate a concept called data protection by design or data protection by default, which are kind of two sides of the same coin. By design means from the very beginning, you are thinking about data protection when you design your service or product. And by default means that everything by default in the way your system works is going towards greater protection or of an individual's privacy. That they would have to make a choice to be more lenient versus the other way around, which is usually how it goes. Unlike the US, the European Union allows people to bring causes of action, even if they have not actually suffered a harm, just because you violated, the language of the statute, you're still allowed to bring a claim against somebody. The US is a little different. You have to have what we call standing, and the injuries have to be concrete and particularized. And this is usually brought up by the defense bar in any privacy case, that the damages are not concrete and particularized, meaning, okay, there's a breach, but what happened with the data? Nobody imitated me or used my data to claim Social Security or open up credit cards and run up my debt. If none of that happens, usually the court sides with the Supreme Court decision that requires this sort of proof. The US, since we just talked about the US, is a bit messier than Europe. It doesn't have an overarching privacy law, which is difficult at times. They're all slightly different, and it could depend on what it is you do and where you have customers. It gets, like I said, very messy. If you are in healthcare, you have to worry about HIPAA. If you are in the financial sector, you have to worry about the Gramm-Leach-Bliley, which is GLBA. Much like Europe, the states are coming up with laws that are what we call extraterritorial, meaning it doesn't matter where your company is. If you're processing data of individuals in those states, the laws could apply to you. There's a few exceptions, but that is the general tenor and common concept in all privacy laws. Unlike Europe, we are less, and unlike Canada too, we are less consent focused. The US is very, well, we'll do it and we'll give them the chance to opt out versus let's get their consent first and let them choose to do this. It's, ask for forgiveness later approach. The CCPA was the big bad privacy law in the US starting in 2020. It was passed in 2018, but went into effect January 1 of 2020. It was very unique. There were a few privacy laws here before it, but it was very unique in that it had some elements of the GDPR, but not all. It protects the data of people residing in California, but it doesn't apply to every single company. you don't necessarily even have to be based in California. Even if you're based in California, it may not be applying to you. The way I like to remember it is 50, 25, 50. So if you have the data of 50,000 or more California residents, if you have 25 million or more in annual revenue, or if you derive 50% of your annual revenue from the sale of California data, the GDPR will apply to you. It's any of those. If it's more than one, it still applies to you. If it's any one of those 50, 25, or 50 items that I talked about, it applies to you, even if you don't have 25 million in revenue, just because you have 50,000 residents data. But like I said, it's not a perfect fit for the GDPR. So if you get big enough, chances are you have to apply both or comply with both, and that you're going to have to take on extra obligations because they just don't perfectly align. The CCPA requires notice at or before the point of collecting data. You could have a separate CCPA notice if you want. I tend to put the information has to be in the notice into privacy policies because you're not required to have a standalone data, and trying to track and update two documents I find gets messy. So I just tell clients to, put a little pop-up link to your privacy policy and handle it that way. And then you only have to do one round of updates. Much like the GDPR, you have to make them aware of their rights. So that's usually something that goes in the privacy policy, Karen, if you want to note that. You have to tell them about their right to know what's being done with their data. Is essentially the same as the GDPR. Their right to delete, again, same as GDPR. Their right to opt out of sale. Now, this is unique. This does not pop up in Europe at all. Sale is a very unique term in the CCPA world. It doesn't have a very clean-cut definition. When we think about sales, we think money for goods, right? It's not that way under the CCPA. It can be money for data, but sale also includes anything of value linked to the exchange or disclosure of data. That could be services, that could be other data. It's a little bit all over the place. And again, just like trying to figure out a perfect transfer of data from the EU to the GDPR, this is something we're all still trying to figure out exactly the best way to do. The good news is this California Attorney General is starting to enforce the CCPA. So we're getting bits and pieces of guidance in from that. And hopefully in the next year or so, we'll have a very firm understanding of what it is that courts are interpreting to mean sale of data. Adults, you have to opt out of the sale. Minors under the age of 16, you have to get their consent upfront. You have to have them opt into sale. So it's a little bit different there. The final right is the right to non-discrimination. This is not what we typically think about when we think about discrimination. This is if the consumer exercises one of their other rights under the CCPA, that you will not basically impose any negative consequences on them. However, there's certain exceptions, like if they ask you to delete their data and you need that data to do some task for them, you can let them know that, hey, if I don't have this data, I can't do the service for you. It's actually an exception to the deletion rule, but basically like that. I mean, if you're, let's see, another exception would be if you're offering them some sort of incentive or reward to give you more information or to let you do more with their information than they originally asked you to do. If they say, hey, delete my data, or I want to opt out of what this extra processing could be, the sale of my data, you can take away that incentive you gave them, but you can't do anything else. You can't charge them more than what you charge anyone else who, for the base, I guess, processing you might be doing for them. It has to be all compartmentalized. You also have to be able to, under the CCPA, accept and receive requests from the consumers to exercise their rights. The CCPA says you have to have two methods to do this. Usually everyone goes for email, but if you have a honest to goodness brick and mortar establishment, you sell goods and you have a person-to-person interaction with your customers, chances are you also have to have a toll-free number if you're not a purely online digital service or company, which again, it's something you can give to another company to do the 800 number, 866 number, so on, but you'll need that toll-free number set up as well. So like I said here, sales of data under the CCPA, it's new. You never saw this in the privacy law before. It's very broadly drafted. We're not sure exactly what valuable consideration is yet. The one way to get around just by pure language in the statute of the CCPA, even being accused of selling the data, is to make a company that you disclose data to a service provider. Now, there's a few different types of entities in the CCPA. There's the business, which is kind of like the controller. It's the GDPR equivalent, or the CCPA equivalent of the controller. There's service providers, and there are third parties. So you can sell data to third parties. You cannot, by statute, sell data to service providers. They have special privileges because you enter into an additional small agreement, maybe half a page, with 3 or 4 little obligations that they have to agree to. If they agree to that, they're a service provider and you physically cannot sell them data. Now, if you don't have service provider relationships set up with your vendors and you are getting something of value from them, chances are you are selling data, or at least it's safe to bet you might be selling data, or that someone might accuse you of selling data. So if you want to go down that road, you have to do one additional step and put a "do not sell my information" link on your website, which nobody likes to put on their website because it has a negative implication to it. But basically, this has to quickly and easily allow them to submit a request to you to stop selling their information. But that's the trade-off. You can either do all the service provider agreements, or you can do the link. It's hard to split the hairs in between and say I neither have service providers nor am I selling data, because it's so broad. We don't really know where the lines are yet. Fortunately, unlike the GDPR, there is no absolute obligation to make any contracts with anyone. You can choose to do this with service providers, but you're not obligated to. You have that other choice of the link. Penalties, much lower than the GDPR. It's $2,500 per violation, or $7,500 per violation if it's intentional acts that you are doing. Now that's per person, you should know, but still, that's going to add up to much less than 20 million for most startup companies. What you have to worry about, unlike the GDPR, is there's a private right of action that allows for class actions. So either the Attorney General of California can bring a claim against you, or the individuals can band together in a class and sue you. Class actions are problematic for a lot of companies because usually they have the advantage from a capital perspective and can wear down and outlast the individuals who bring claims against them. But class actions level the playing field in that sense. To avoid falling victim to the private right of action, the CCPA says that the class action or the private right of action only applies for breaches of data that is neither encrypted nor redacted. So if you are either encrypting or redacting your data, you essentially sidestep the chance of the private right of action. Redacting, for those that don't know, is the bane of most attorneys' existence, especially when you're very young and newly minted. You take a Sharpie and you cover over sensitive information, and then you make copies of those papers to make sure you can't see anything. There's software for it these days, but it's much more complicated and probably more expensive. I'm sure it's more expensive than simply encrypting the data. So again, encrypting, good. Encrypting, fast, easy, and it's viewed favorably by the European Commission as well, even though it's not a specific requirement. So there's so far no reason to not encrypt your data, other than maybe you can't afford it at the moment. But as soon as you can, I suggest you do. All right, so those were the two big privacy laws. Now we're getting to the IP section. Andre, honestly, it's all over the place. You don't need end-to-end encryption, though it's usually best. I won't tell you how many bits of encryption you need. Typically, the rule is keep up with your peers. If your peers are using a certain type of encryption or a certain degree of encryption, follow that. You know, competitors, whatever they're doing. If you don't stand out in the crowd, chances are they're not going to come after you. The CCPA doesn't say you have to have at least this much or this type of encryption. It just says encryption. So take that for what it's worth. So circling back to Mohan's question, if a technology has been published in a reputable tech journal and a patent is applied for, okay, Mohan, I might need you to reword this. If I am asking for a license, am I covered? Or can people copy technology based on the publication? Am I protected if I pay for the license from a government lab? Mohan, if you could try to reword this, I'm happy to answer it for you. Patent law in the US gets a little complicated. There's certain safe harbors that allow for publication before you file, but you have to be very, very careful that you don't blow your statute. You have, I believe, 1 year under 102B of the patent statute, but it's best to always file for your patent applications before publishing anything. Even if you have to file a provisional application, which it's added expense, but it's quick and it's simple and it gets you a place in line so that you can publish. Mohan, if that is not what you're asking about, let me know, because I see references to license here, and I'm not sure if you're talking about your IP or someone else's IP. When you're dealing with IP and government entities, if they're funding you at all, chances are you're losing rights in your IP, and you have to give them a license forever. You might even have to share something. So it's, you know, there's gives and takes to every relationship. So for startups, generally where we see IP popping up is one, with your employees. Before anyone starts with you, have an IP assignment and confidentiality agreement in place. Most IP rights by default belong to whoever comes up with them. There's certain assumptions made for employee-employer relationship, but you want to be very clear and objective if there's ever a dispute saying, no, they started on this date, they signed this agreement with us, they came up with this information on this date. Usually it'll have a little list on the back of the things they've already come up with. So you can say, well, you know, if you really came up with this before you started with us, why didn't you include it on this list? So definitely get those agreements in place with your employees first before they start coming up with something that's truly valuable to your company. You don't want to have to fight about it later. And then agreements with third parties. Same as above, you want to get as many of the IP rights associated with the work done with third parties as possible. If someone's creating code for you, limit what they can rely on, and then get as many licenses as you need, absolutely minimal, because you don't want to have to go back to them and rely upon them in order to use whatever it is that they created for you. So one, limit what it is they can use of their own materials, and certainly limit what it is they use from third parties, especially open source software. I mean, you can kind of extrapolate that to other scenarios, but always limit what they include in your materials that they're making for you. Make sure it's all original to the extent possible, and limit whatever rights are going out to them. They should have note rights. Customers might need rights to use whatever it is you're producing or offering as a service, but we can talk about that in a bit. So one of the primary, a few more questions came in. primary IP rights in the US is patents. So I see more explanations from Mohan. I'm in the process of technology transfer from a government lab. I have to pay fees to the government. Yes, those are called royalties. This info has been published in a tech journal. Can others copy this technology because it is published? I am wasting my money. Am I wasting my money in this technology? Not necessarily. I don't know who published that information. So if it's one of the government workers that published it and they're the ones that own the technology, publishing it doesn't negate their rights if they published it first. Though I don't think the government can actually. Okay, the author of the technology published it. Well, if he's associated with a government agency or a government-funded university, chances are he doesn't have exclusive ownership. So there's more circumstances here that we need to talk about. At this point, I think we're getting very involved. I'm not sure who VA Labs is. We can talk offline though, Mohan, because this seems like a very in-depth and specific set of circumstances that I don't know is going to help everyone in the context of the half hour or so we have left. My contact information will be on the last slide. So patents give you the right to exclude or prevent others from doing things with a certain technology. It applies to inventions and designs and plants. Yes, actual plants like green, chlorophyll, producing oxygen, taking in CO2, plants. There are utility patents that last for 20 years from the date of filing, subject to certain extensions depending on how the patent office is doing with their backlog. And there's two types of utility patents. They can be provisional or non-provisional. The non-provisional are the ones that most people think about when they think about patents, and they're the 20-year protection. Not the provisional ones, essentially is a 1-year holding spot for you to file your non-provisional application. So you can essentially have 21 years of protection if you schedule this right and talk to your IP attorney. Provisional will let you get to market faster and publish and do a few other things. It's a little bit of an added expense, but it can also help make things easier when you go to your non-provisional application because you've thought about one or two of the items that are in both, and it makes things easier. It also means you have to be a little bit more developed in your invention, so it makes it easier when you get to the non-provisional filing. You have to file the non-provisional within 1 year of the filing of the provisional application, otherwise it's all public record and you are out of luck. So to get a utility patent, your invention must be new, useful, and non-obvious. New meaning there's no existing patents out there that cover that. Non-obvious meaning there's no very seemingly obvious combination of one or more existing patents or a patent in a publication out there that says, well, you didn't really create anything. It was obvious to try this in light of this. Design patents, purely designs of items. For instance, I think the Coca-Cola bottle is probably the best example to use in every single one of the IP sections we're going to talk about today, because there's a design patent on the Coca-Cola bottle because it has a very unique shape compared to every other soda bottle out there. The curvature of it. It has no functional purpose, but the design of it is protected. And then plant patents. I honestly have never seen or read a plant patent, but they do exist and they do last for 20 years. I think this might actually be very good to examine if you're in the CBD realm or the cannabinoid realm, because I imagine there's going to be unique strains out there, but not my area of practice, just making you aware of it. 20 years protection. Pros and cons of patents. They are very strong intellectual property, very, very strong. Like I said, they prevent others from making, using, selling, importing in this country. US patents only protect this country. There's patents in other countries throughout the world. There's European patent system, there's China, there's Japan. Wherever you are going to be operating, think about an IP strategy in those countries to keep out competitors. Again, talk to your IP attorney about that. Cons, they are far and away the most expensive type of intellectual property. It takes the longest to get these. Last I checked, the tendency for a utility patent, particularly in the electronics and like code and programming and software space, 3 years roughly before someone picks it up and looks at it. So in the meantime, you're left waiting and wondering, and then it might be another year or two before you get to finalize the patent. You have to go through some back and forth with the patent office sometimes. It is also the shortest term of protection, 20 years. We'll talk about the other terms as well, but 20 years is not that long of a period when you're talking about the life of a company, especially if it's a very important piece of technology for that company. There's certain areas where it's very hard to get patents based on whatever your goods or services are based on recent Supreme Court law. Software is one of them. A lot of people argue that software is an abstract idea or a basically an automated idea. You're replacing what something a human can do with basically a calculator. Like we can all do subtraction and addition, but a calculator does it faster. So the patent office would say, that's not really an invention. That's just speeding up the process. You didn't invent anything. You coded it to do things faster. There's nothing novel there. They also say that abstract ideas, laws of nature, natural phenomenon, not patentable. Recently, the US changed to a first to file format. And I say recently, I mean within the last 5 to 10 years. Before that, we were a first to invent, which created a whole new set of disputes. Basically, people arguing, well, my lab book said my patent, I started working on this September 1, 1990. Mine says 1988, and so on. It turns into a huge dispute process, which I guess was good for IP practitioners at the time, but I never really saw it. Trademarks. Trademarks are also an exclusion area, right? You see these all the time. They apply to names and logos and slogans. They can have this circle R on them, or they can have a small t and an M. The difference between the two is the circle R means it's a registered trademark. TM means it's something that someone considers to be their trademark, but it doesn't have the same federally granted rights associated with it. It can also mean that they are in application to get the federally issued trademark. So a trademark allows you to basically exclude someone from using the same mark or a substantially similar mark on the same or similar goods or services. Basically, the goal of trademarks is to avoid consumer confusion and indicate source. So that's the whole goal of the USPTO. And if you think someone is confusing the public with their name compared to your name, or blurring the lines, you probably have a good claim against them, or at least send a cease and desist. Good news about trademarks is they are relatively inexpensive. A few $100 for the government fees and then whatever you pay your attorneys. And the process is usually 12 to 18 months, but they're potentially infinite. You just have to pay a renewal fee every 10 years or so, but they can go on and on forever and ever. One thing to consider as a startup, if you have not incorporated or formed yet, check both the availability of the name of your company in the state of Delaware, which is where investors like to see all the companies formed, and at the USPTO, because it helps with branding and driving the point home with customers. So if you have both a federally issued trademark and the rights to the name in the state of Delaware, you're in a better position than if you have only one. Copyrights give you the exclusive right to reproduce copies, make derivative works, distribute copies, publicly perform, publicly display. And for certain sound recordings, perform them publicly via digital transmission like the radio. So it's a few more rights than the other IP realms, but it only applies to these creative works that, like a song or a statue, sculpture, books, anthology series of music or books. Software can be copyrighted because, as you'll see in the next slide, it's fixed in a tangible medium of expression. That could be on a remote server and accessed via the cloud, but it exists somewhere. Copyrights only apply to original works, like I said, music, software, anything written, anything dramatic. And it technically applies as soon as you fix that original work in the medium of expression. You could write something down on a piece of paper, put it in your desk drawer. You have a copyright. But a Supreme Court case roughly 5 years ago said that you cannot enforce a copyright unless and until you register it with the Library of Congress. So you'd have to go through the filing process, which is roughly 12 months, very minimal expense, $50, $60, something like that. And it lasts for your entire life or the life of the latest surviving author that contributed to the work, plus 70 years. So the joke in the industry is that the term of protection for copyrights goes up every time Mickey Mouse is due for expiration. And the Disney fights in lobbies to get that extended so that Mickey Mouse stays theirs. Trade secrets, last but not least. It's different than all of the other IP rights that we were talking about because it's something you derive value from, but you never have to file. You never have to make it public, which as soon as that's the trade-off for the rights you get with the other IP rights, is that it eventually becomes, except for maybe trademarks, part of the public domain, and that other people get to practice them, whether it's patents or copyrights, trademarks, if they are allowed to lapse and they're not renewed, people can practice them. Trademark or trade secrets never go out into the public. If you again, like Coca-Cola, only 1 or 2 people know what the secret formula is, and they might only know half of it. You might need both people in order to put the full formula on a piece of paper. You have to take active steps to minimize the disclosure and the number of people that know your trade secrets, and you have to protect it when it's disclosed with very strong confidentiality. But you don't have to file anything. So there's added savings from not filing anything. And you do have to have the expense of trying to protect the information within your own organization and with those few organizations you trusted with outside. So you really have to protect it and take steps to actively protect it. If you don't do that, it won't qualify under the Trademark Defense of Trade Secrets Act. And people poke holes in it and say, it's not really a trade secret. So licensing. This will be a big one for a lot of companies. Sometimes you need to license third-party materials in order to get your product operational or your service to operate generally, or to just be ready for sale. And when I say licensing, I just mean to get the right to use. Mohan, you know what I'm talking about. You have to be careful, though. You have to really look at the IP provisions in each of those agreements. Be careful, especially if someone's making something for you, that they are not allowed to use anything open source, because certain open source software requires that anything that is made using the open source software itself becomes open source software. So you could have spent thousands and thousands and thousands of dollars to develop unique software for your company that is proprietary, that is very valuable, and one of your coders used open source software. Your very expensive software is now available to the public to use freely. And you shouldn't really hope that nothing is ever discovered, but chances are it could be. So 1, don't let them use any open source software. 2, minimize their own software, their pre-existing intellectual property. And if it's absolutely necessary, you can improve it, but make sure you get an irrevocable license so that you can use it forever and ever and ever. Make sure that you own any derivative works, which means anything created based on the materials you give them. Now, there's issues with customers needing licenses as well, but to effectively sell your service, you need to give them a license in some instances, especially if you're doing some sort of code. Okay, sorry about that. Just making sure I'm not leaving anyone in the lurch. You want to make sure that they have very limited rights to customers, and that anything they create that is not, I guess, strictly needed for their products or services falls back to you, like feedback and suggestions that they make. Obviously, you don't want to leave a bad taste in the mouth of your customers, and if it's something that is not valuable to you, or that is going to be something you grow into, it makes no sense to want to take anything they create from use of your software or product or service. So you have to do that mental math and figure out where you can give and where you can take. But I would always start off having the most amount of IP protection and rights given to you as possible. So winding down, back to privacy. Before you this is our good roadmap to have, and it applies to all the privacy laws I can think of. It's not specific to the GDPR, CCPA, just things to think about and try to implement. One, before you collect any personal information, have a privacy policy up on your website. Make sure the people who give you information see it, or checkbox agree to it. You would also want to do what we call data mapping or assessment, basically trying to figure out what data you have, what you're doing with it, where it comes from, and what laws apply. Now, you can wait a little while before that happens, but it's something to think about early, even if you don't do it. You have to have a system in place for receiving and tracking requests that you get from data subjects or consumers, and you should have a point person in charge and responsible for responding to those requests in time. When you're supposed to. There's like 30-day, 45-day statutory periods to respond. Roughly 12 months out before your price round, I would suggest thinking about your data map, which is like an inventory, figuring out the who, what, where, when, and why of the data you have, and seeing what laws apply to you. Like I said, they're extraterritorial. They will reach you even if you're not in the country that they're designed to protect, but not in every instance. So you have to talk with your IP or your privacy attorney and figure out what laws actually apply to you. Protect the data. That's a good suggestion early and often. Don't sleep on it. Find it inexpensive but effective encryption software and use that. 6 months or so before you go for funding or start talking to VCs, start the contracting process with if the GDPR applies to you. If you don't have too many, I've done work for clients where it takes over a year, and you're just calling and trying to chase down these vendors, trying to get them to sign the agreement. I personally draft these agreements so they're the absolute minimum to get to compliant. Some people put fancy bells and whistles and try to get more than is necessary to get to compliance. But I try to explain that to the vendors, and they're just afraid to invest the time, money, or legal expense to reviewing them, and they just try to ignore it. So I guess when that comes around, if you have to hit them with this requirement at renewal. You have to say, well, here's your 60 days notice, 30 days notice. I'm not going to renew you if you do not sign this agreement. Pitch deck. Mohan, for pitch decks, there's no set amount of data. You want to put enough in there to pique everyone's interest and show effectiveness, but you don't want to give away the baby in the bathwater. You want to not give away the secret sauce, as it were. So don't tell people how you did it, but show people what happens when you do what you do. You should have everyone sign a non-disclosure agreement, but venture capitalists and investors will say, that they'll add a right saying that, just because they're entering this non-disclosure agreement with you doesn't mean that they can't talk to similarly situated companies with similar products and similar goods and services. The goal is, as long as they don't violate the NDA with you and disclose your information to those other parties, that it's not going to be in violation of the NDA. It's very common to ask for the NDA. Depending on how much you put into the pitch deck, you might want to weigh it out with your attorney and say, do I really need an NDA here? Sometimes they'll say, no, you're probably okay. But again, it's case by case. I can't make general overarching statements like that. The thing to know about privacy and IP is investors will want you to represent and warrant that you comply with all data privacy laws. And depending on what you're offering, goods or services, if data is a big part of that, that's a big asset. Like if you're training an AI to do something, you just need stores and stores of data. Chances are they're going to go a little bit deeper than just representing and warranting that you comply with applicable law. They're going to have follow-ups. They're going to have additional obligations and reps that you're going to have to make them feel comfortable giving you a bag of money. So be prepared for that. And like I said, start planning ahead of time. There's nothing worse than having a client or being the company that has this investor that is super excited to give them millions of dollars. And then they find out you're not compliant with the privacy law and it's jeopardizing your value. And it'll take you 3 to 4 months at least to get compliant and backwards engineer all the things you need, whether it's consents or otherwise, to be in that position to get the funding. And by then, the investor might have moved on and invested in someone else. So you have to start the process all over again, which is why I say, do this early, do this ahead. I know it's an expense, but the old adage is you have to spend money to make money. And the investors want to make sure that they're putting money in a smart investment. And you can look at it this way too, is that customers like to have people who work for them who are compliant with various things. So it's a value sell to customers as well. It's a differentiator with your competitors. We talked about extraterritorial already. IP, think about it early and often. This is usually the big asset for most companies, whether it's code or some sort of unique platform. You have to protect it early and often. Make sure all your assignments are in place. This is something that every investor I know looks at. Make sure that everyone has that assignment for all employees as of the date they start, just to make sure that everything is definitely vesting in the company. They don't want any ambiguity with this respect, so they want to see the agreements in place. And with key vendors too, if you need a license to have everything work and it'll turn off the lights for your service if you don't have it, they want to make sure that it's a solid license in place for several years and that everything's been paid properly. But again, come up with your own strategy for where and when to file with your IP attorney or your venture capital type attorney to make sure you have all the agreements and assignments and IP filings in place. Like I said, investors are very, very, very focused on these issues. And I'm done. JJ.
All right.
I didn't talk your ears off.
No, this is great. Any more questions from anyone? Mohan, dominated the questions today.
I tried. And like I said, Mohan, feel free to, shoot me an email, give me a call after the fact.
Yeah, that's really good.
And anyone else too, not just Mohan. Don't let Mohan steal the show from me. I'm happy to talk to anybody.
Yeah.
Good job. Very funny, Mohan.
Exactly.
It's okay. I know everyone needs, a give and take in the presentation. So, anyone else have any questions?
Andre, you want to hear? I'll bring you in to ask a live question. Here you are.
All right. Hey, first let me just give an affirmation to JJ. Thank you so much. These webinars have been relevant. And Morgan, I'm glad you did a lot of talking because between you were very.
Uh-oh, you muted yourself.
I clicked mute by mistake. Unmute. Sorry.
Here we go. Here we go.
Maybe you're gonna take back that affirmation right now.
Yeah, right. No, thank you, but thank you very much. And I was fighting myself to ask a deeper question on encryption because we've been doing some research on homomorphic encryption, which allows the third party to only pull off the information that they're allowed to pull off while it's bare information heading back into the blockchain per se, or otherwise. So, like, in other words, instead of your full date of birth, it would just give the month and year, and they can only see that information while the other information continues to ride through. So I was just interested like in what's out there, but if you've heard of that as well and how that.
No, I have heard of homomorphic encryption. It's just not something that I talk about very often with people, so I'm not as well versed in it as I could be. That's a very technical question. Like I said, I have yet to see any data privacy law that says you must have homomorphic encryption or any specific type of encryption. Like I said, they're usually pretty good about saying, not everyone's Google. We can't force a specific standard technical security on anyone because they might not be able to afford it, and then we crush small business, which would be detrimental to the country as a whole.
Okay, great answer, because I guess I was trying to bring a sledgehammer, to a.
Oh, we can talk about it some other time. I don't think I'm prepared for it right this second, though.
All righty. Thank you so much.
Absolutely. Thanks, Andre.
Thanks, Andre. Anyone else would like to come in and ask a question?
We have Karen, we have Andre, we have Patty, a few others. Anyone else?
Here's Andre again.
Really?
Okay. Oh, Adam, sorry.
That was a mistake. I'm sorry. I thought I was lowering my hand. Sorry.
Okay. All right. No problem. Okay. Anyone else? All right. Well, it's we'll give you another second here, but Morgan, that was really great. Again, it's one of those things like California creates something, but I learned from you today that although you don't have to be in California, you said, or even if you are, some of these don't apply to you, depending on the size, right, and all that. Mm-hmm. But if a company is doing business in California, and they are based out of Delaware or New York or whatever, do they still need to abide by the CCPAs?
Not necessarily. It has to hit one of those threshold criteria. You have to have the 50,000, the data of 50,000 residents of California, $25 million in revenue and California data in your database. Or you have to 50% of your sales or your revenue each year comes from selling.
So if it's Verizon, then yes, right? So.
Yeah, probably. yeah. Most of my clients, not so much, not yet at least.
Yeah, exactly. But if it's a startup out of New York, they don't have 25 million, all that, then it doesn't really.
They could have 50,000, or they could have 50% of the revenue from sales. So it can get you a couple different ways. Okay. We all hope it's going to be the 25 million, right? Like that's what I hope for all of my clients, is that's what triggers the CCPA issue, and that they're doing great and they're way past all their rounds of funding. Right, yeah. All right, Mohan is asking, and what I'll for the slides. So if you could send me those, what we'll do is we'll put them in the description of the YouTube video, so they'll be available there as well. We'll have the link there, so everyone can download the slides as well as being able to see the video. Another question from Mohan. Check name of corp only in Delaware or national? I would say just in Delaware. Like I said, investors want to only deal pretty much with Delaware corporations. A lot of our clients start as LLCs or corporations in other states and we have to convert them over to Delaware corporations before they go for funding, because the investors don't want to think about all the different rules of the different states. They really just want to deal with Delaware. So that would be the important one. It's best to probably just originally file, probably cheaper to just originally file in Delaware than to do the conversion. And then you can register to do business and get licenses in the other states. It's usually cheaper, one state at a time to do that than a conversion to a Delaware corp.
Yeah. All right. Well, thank you everyone for being here today. Thank you, Morgan, for a great webinar. Much appreciated. And I'll send you the link to the YouTube video as well.
Great. And I'll send you the PDF version of the presentation.
Appreciate it. Thank you all very much. Have a great day. We'll see you.
Have a nice day, everyone. Feel free to contact me if you'd like.